of the relationships and the work we have with some of our city officials. And I want you to know that I think it helps, well, I know it helps us, but it helps keep our readers informed of what's going on. So I'm going to reach out and recognize a few of those people. And did Pat come in yet? Pat McGinnis? Gordon Gallagher, I saw him. Gordon, thank you. Christine, thanks for coming. Craig Bessinger with the City of Ferrysburg, thank you. And did Jerry McCalo come in yet? Didn't see her either. The mayor of Grand Haven. But those folks work hard to help us stay informed at the Tribune, and in turn it helps us keep you informed. So thank you very much to all of you. Dana Nessel honed her skills with the Wayne County prosecutor before starting her practice as a defender of constitutional rights and the rights of indigent defendants, and as a premier litigator of LGBTQ issues. She challenged Michigan's bans on adoption and marriage for same-sex couples with De Boyer versus Snyder, the landmark U.S. Supreme Court case that legalized same-sex marriage nationwide. Nessel founded the, I gotta get rid of these cheaters. Founded the Fair Michigan Foundation, and with Wayne County prosecutor created the Fair Michigan Justice Project to prosecute hate crimes. She's received numerous awards for her civil rights initiatives, including the Champion of Justice Award from the Michigan Bar Association, Women of the Year from the Michigan Lawyers Weekly, and Treasurer of Detroit Award from Wayne State University Law School. University of Michigan and Wayne State University Law School graduate. Nessel lives with her wife, Alana McGuire, and their twin sons, Alex and Zach. Please welcome with me, Michigan's 54th Attorney General, Dana Nessel.
But I'm really happy to be here, and I'm thrilled to be here during Sunshine Week. Happily, the weather has sort of cooperated with that. It's an exciting time because obviously these are incredibly important issues. And I think nowhere more important really than in Michigan right now, since last I saw us, we had an F grade on transparency in this state. So I'm really hopeful that I can be part of the process of taking that F and turning it into at least a C minus. Yeah, we'd like it to be an A. But anyway, I want to thank, where's Lisa? There she is. Thank you for your partnership and helping to reestablish these very important seminars. And these are important topics, not only, of course, to your members, but also to my office. And I want to thank Kevin. Where did Kevin go? Oh, there he is. Thanks to Kevin Huck, of course, the publisher of the Grand Haven Tribune, who is the Michigan Press Association's new president, right? And congratulations to that. I want to introduce some people from my office. This is Tom Casarano, right over here. He is our FOIA guru and has been for how many years now? 31 years. That's amazing. So he knows this better than probably anybody in the state, I would say. And we're really lucky to have him at our office. Also from my comms team, Dan, where's Dan? Dan Olson over there. And we have a couple of our investigators here, Dave and Derek, keeping us all safe. And my Deputy Attorney General, Kelly Keenan, who I dragged kicking and screaming back to the office. He also worked there under General Kelly and Granholm, and was kind enough to come back to show me the ropes in that office. So, you know, I'm really thrilled to have them here and to be here with all of you and to be a room full of local officials, elected and otherwise, to talk about the Freedom of Information Act, which of course we know as FOIA, and the Open Meetings Act, known as OMA. because these are two of the most important tools that reporters have to, keep us honest and to keep us on our toes when we work in government, right? And I'm pretty sure we have a few of the fact seekers and fact checkers here and the journalists who are committed to finding out what's going on behind closed doors, no matter where those doors are, and opening those doors up to the rest of us. Now, I've been told that these FOIA sessions were started in tandem with the Michigan Press Association by the Eternal General, long-serving Attorney General Frank Kelly, still the longest-serving Attorney General in United States history, although I saw Tom Miller from Iowa the other day, and he's just about to eclipse that. So Frank Kelly, who I think is 94 now, right? He might want to think of running again in 2022, just so he can get that record back if he loses it. But I know he was really committed to doing these, so were AG's Granholm and Cox. And unfortunately, these fell by the wayside for the last 8 years, so it's really an honor for me to restart that tradition. And of course, what better time to do it than during Sunset Week, or Sunshine Week, hopefully not sunset, to reignite these seminars and have this renewed partnership between our office and the MPA. I'm very excited about it. So for elected officials and governmental entities, including me, we're constantly receiving requests for information, and that's appropriate, right? We should be receiving those requests. The media is the public's watchdog, and unlike some others, I do not subscribe to the theory that the media is the enemy of the people. In fact, I believe the media is the people's best friend, honestly, and that we deserve, as public officials, to be under the microscope. We serve the people, and they deserve to know what we are doing and how we're doing it. And so, it's upsetting to me. I mean, I'm embarrassed that Michigan is the only state in the nation in which state law actually exempts the governor, the lieutenant governor, and the legislature from requirements of the state's Freedom of Information Act. It's awful. And not only that, but we are one of only 8 states that receive a failing grade for integrity from the Center for Public Integrity. We are absolutely failing. There's no question about it. Now, to add insult to injury, there are actually Attorney General opinions, not mine, to be clear, that opine that the Michigan legislature is also exempt from FOIA, and not to be left out, the Michigan Supreme Court exempted itself from FOIA requirements. So since it is Sunshine Week, I feel compelled to point out that not only are we at the state level not opening the doors, but we are locking them with deadbolts, and then we're nailing boards across those doors. And also there's a moat or something around there. So, you who are here who are elected officials, though, you are absolutely and totally FOIA-able. And so am I, unless it falls under the guise of attorney-client privilege. And let me say, in case it's not abundantly clear, that I am a big fan of transparency in our government. I believe in it, and I believe in promoting it. And so do others, but apparently not enough, right? So, for example, in the last legislative session, there were efforts to establish a 9-member open government commission, subject to both FOIA and the Open Meetings Act, and that would receive and respond to citizens' complaints in regard to public body responses to FOIA requests, and issuing binding opinions overturning a public body's assertion of an exemption, exclusion, or a privilege in response to a FOIA request. And that was a great idea, but unfortunately it failed. There was even a 10-bill bipartisan, let me say that again, bipartisan proposal to create the Legislative Open Records Act to bring the legislature under FOIA and to strike the exemption from FOIA for the governor, the lieutenant governor, and executive office employees Another great idea that went absolutely nowhere. Now, finally, there was an effort to require under the Open Meetings Act that board and commission members, with limited exceptions, be physically present at public meetings in order to be able to vote. Now, that doesn't sound like rocket science, does it? But again, that was met with no success at all. A government accountable to the people is at the core of the United States Constitution. Can we all agree on that? And in Michigan, all political power is inherent in the people. Or in other words, open and transparent government is part of the law of the land. The Freedom of Information Act and Open Meetings Act are supposed to promote and safeguard the First Amendment, the freedom of speech, the freedom of the press, and freedom to petition the government. And when it all took effect in 1977, FOIA was supposed to provide a means for the people to be informed about their government, its officials, and its employees, so that they could fully and actively participate in the democratic process. Which means we, as the government, have an obligation, a responsibility, and an opportunity to meet the spirit and the intent of the law, ideally without putting the public through unnecessary hoops to get the information they want and that they deserve. And I am excited about the conversations that I'm having with the Michigan Press Association to reestablish these FOIA workshops around the state, in which we can join forces together to share best practices, advice, and guidance for local elected officials. Also, they brought some amazing cookies, so that was just a bonus. But one of Governor Whitmer's first executive directives, you may remember, banned the use of private email to conduct state business within the executive branch. Then, yeah, that was great. Let's clap for that, right? Then at the Michigan Press Association's annual meeting, which I believe I was supposed to go to, but there was a polar vortex of some kind, I think the 10th we've had so far this year, the governor signed an executive directive that ensures extensions in response to FOIA requests, and that they will be the exception, not the rule. And she went even so far as to require that each state department now have a FOIA liaison who works in tandem with the FOIA coordinator to ensure prompt responses to FOIA requests. Governor Whitmer took it even a little bit further during her inaugural State of the State address, when she called on the legislature to open up her office as well as the legislature to FOIA. Now, these are incredibly important steps, are they not? So perhaps all is not lost in our state, and there is definitely a renewed interest in the legislature. And in fact, last week bills were introduced to open up and bring sunshine to the executive office of the governor and to the legislature. So there definitely is some hope. And as Lisa McGraw put it last week, we've been at this a really long time, a long, long time. And also to quote Jane Briggs Bunting of USA Today Network Michigan, "At long last, Michigan citizens may have a real chance to get some statutorily required sunshine in the offices of the governor, lieutenant governor, and state legislators." So I personally am encouraged by Governor Whitmer's steadfast commitment to ensuring open, accessible, and transparent government. And my office shares that commitment, which is what brings me here to be with all of you today. So now let's get in the weeds on these very important issues of our democratic process and talk a little bit about FOIA and OMA. So we'll start with FOIA. And three key issues I know are at the top of your list, as they are mine. Now, a FOIA request can be submitted by anyone. In our office, we get requests from reporters on a daily basis, but we also get requests from individuals, attorneys, and out-of-state groups with names like Treasure Ireland and kit de litter. These are real requests that we get in. Now we can't and we don't discriminate against who has a legitimate request and who's just fishing around, because we think that every request is legitimate. And we may not have what they're asking for, but we are obligated to look to see if we do. So let's start with, what is a FOIA request? Well, it's a written request that describes a public record sufficiently to enable the public body to find the public record. Now, just last year alone, our office received 486 FOIA requests, and now just in the 2 months that I've been in office, we've received 86. So to break that down a little further, here are the steps to that request. A person asked to inspect, copy, or receive a copy of a public record by making a written request for the record to the FOIA coordinator of the public body. And a written request can be sent in by email, by letter, or by fax. The FOIA is then considered received 1 business day after the receipt of the electronic transmission and day of when it's sent in the U.S. mail. So from there, the FOIA coordinator will determine whether or not the information is available, and if so, process the request. And if not, a letter of denial is sent, although this is sometimes a little confusing to the recipient, because if not read carefully, you might simply think that it's denied, where sometimes just that information is not available. But fulfilling the request doesn't always go without question or concern, as some of you might be all too familiar with. And there are 3 questions that top our list from constituents as well as the media. First is this, the cost, right? Section 4 of the FOIA statute addresses limitation on total fee, labor costs, establishment of procedures and guidelines, creation of written public summary, detailed itemization, availability on information on website, notification to requester, deposit, failure to respond in a timely manner, increased estimated fee deposit, deposit as fee, failure to pay on appeal, deposit, request abandoned. I sound like a law book now, don't I? It's fascinating. But this section, what it does is it allows for fees to be charged for obtaining a FOIA request. It's not designed to price a member of the public or media out of being able to obtain the information that they should readily have access to. Fees may sometimes be charged for things like copying of public records, for inspection, mailing, duplication, and also for labor costs. However, that fee can always be waived. It's not mandatory. And I would argue that when the information requested is of interest to the public, it should be commonplace to waive the fee, if at all possible. It's also worth noting a public body cannot charge fees unless it specifically identifies the nature of the cost required to comply with the request. And here's another nugget of information for you. If the public body does not respond on time, the fee is reduced by 5% per day, with a maximum reduction of 50% if the late response was willful and intentional, or within the first 250 words the request says FOIA. And I'm happy to report to date, our office has processed 70 of the 86 requests that we have received so far without any fee whatsoever. So we're already doing better than 2018. And I know I've covered a little bit so far on this, so I want to pause and see what questions you have. And I will tell you, I am starting to familiarize myself with the law the way many of you are since my time in office. So anything real complicated, I'll have Tom take a crack at. But is there anything that we've covered so far that anybody has any questions on? Yes, sir.
How does this whole process relate to records which are usually kept in mass, such as Department of Transportation records and land holding records and other records that are generally been computerized and are in mass, do you have a whole nother process for that, or do you have somebody from Equifax or whatever send you a request and say, I would like your files, and this is my server information, please transfer them and bill me, or not bill me. And you know, is that a separate kind of function? Because it seems that business has as much or more than they need of access to our personal information that has been taken in by the licensing bureau, for instance.
Okay, well, there are, of course, and we'll get to this, but there are exceptions as to the information that can be requested, and obviously those include personal information that you wouldn't want disseminated to just anybody, right? Like social security numbers and driver's license numbers and things of that nature. But in regard to the first part of your question, I mean, sometimes what we have to do at the AG's office is sometimes it's a matter of directing people who make these inquiries to the right place. Obviously, there are a lot of different bodies within the state government, and sometimes what people will be asking for, we might not have it at the AG's office, but we would at least try to say we might want to check with the Department of Transportation or the DEQ or the DNR or whoever we think may have that information and try to be of assistance that way. But what you're saying in terms of other servers, I'm not really clear on your question.
Well, I'm saying, is it a separate process? In other words, for people to know what models of cars I have and what ones are licensed, do they have to go through this process, or do they just have to send somebody with a checkbook over to the Department of Licensing and do it that way?
No, it's the same process. It's the same process in terms of making the request. So I don't think that would be any different. Tom, do you have any?
No, if you're talking about transferring an entire State Department's database, which I'm not sure that's what you're indicating.
Major part of it, yeah.
Okay, in other words, if you're saying I want the Department of Secretary of State to transfer every driver's record in its possession to me, you're going to run into a little bit of a delay in the sense that they're going to say, you have not described records specifically, but you described them, as you said, en masse. Therefore, they're going to have to segregate, by statute, the exempt from the non-exempt, your personal information, your PII, personally identifiable information. You're going to start thinking, why is it that I need the entire database? And I'm not questioning that right this moment. But the process is the same as Attorney General Nessel said. You're going to go through the request, is it specifically described, and then there's a segregation of exempt from non-exempt. You I think you would agree that's going to be a big labor.
Yeah, we would hope that would work right.
Yeah, there's going to be a big labor. Now, what many of the state departments have done, I don't want to speak for the state, is much of that statistical information or other types of data are on the website. So, for example, I want the names of every medical doctor who is licensed and disciplined by the Department of Licensing and Regulatory Affairs. There's a website for that. There's a website for something else. You know, they don't say there's an app for that. Okay, so much of that information is already available en masse, if you will, in a much more segregated way, much more manageable way. I hope that answers it.
Thank you.
Okay.
What he said. All right.
Well, she told me.
Right. So let's move on to the second issue, which is time. Section 5 of the FOIA statute addresses responses and extensions. So once a FOIA request has been received, it must be responded to within 5 days or indicate that we are taking the extension. And these are business days, not calendar days, which oftentimes confuses people. And I will say again that it is a breath of fresh air to have a governor that is committed to free-flowing information to the public, and that sunshine is finally becoming a priority. And I agree with Governor Whitmer that extension should be the exception, not the norm, and that we should be asking for them only when absolutely necessary and not just to delay the process. So with the understanding that sometimes, of course, extensions are important. For instance, if you're asking for every single car that's ever been registered in the state or something like of that nature, you would need an extension, and they are important to ensure a more complete form of information is provided to the recipient and the public. And it is my hope that with the establishment of FOIA liaisons through the governor's executive directive, that we may finally be able to streamline these processes more effectively and get the people we serve responses much faster. And that is something that we're supposed to do. And just again, so I can say this is not some kind of a favor that we're doing to the media or to the public, because the public has a right to know how their government is operating, period. But, you know, sometimes, as you and I know, most extensions are requested out of necessity, not convenience, and certainly not all those requests are simply to stall the process. Now, one thing that I know for a fact is that the civil servants that I work with in my office are incredibly industrious, incredibly hardworking individuals. But here's the facts. All FOIA requests must be responded to within 5 business days after receipt, unless a 10-day extension is taken, making it a total of 15 days. So to respond, one of the following has to be done. You have to grant the request, issue a written notice denying the request, issue a written notice granting the request in part and denying the request in part, or issue a notice requesting an additional 10 business days in which to respond to the request. Now, there's a number of reasons for an extension. Like I said before, you know, the vast majority of civil servants, very hardworking individuals. But sometimes searching for documents and compiling them can take time. And that is the most common reason for an extension. And one would hope that it would be improved at the state level with the addition of a FOIA liaison in addition to the FOIA coordinator. So again, on this time issue, we're going to take a little break for questions if anybody has any questions about some of the time provisions in FOIA. Yes?
I actually wondered, do you have to make your request to the FOIA coordinator, or can you make your request to the person that you think has the materials?
Well, generally it's the FOIA coordinator that you would have to go right to, right? Go ahead.
The statute says, I like this in the statute, says any public employee of that public body who receives a FOIA request shall immediately forward it to the FOIA coordinator. So that's where the process is. By law, only the FOIA coordinator can deny a request. Only a FOIA coordinator can process. Anybody can grant it. But if you want efficiency, you want to make sure the FOIA coordinator has it. It may go right back to the person you sent it to initially, because you knew that person had the records, but that may be the case. But the FOIA coordinator's receipt starts the process. But no matter who receives it, it's not up to you to figure out who the FOIA coordinator is.
That's the problem, yeah.
You can give it to a male person at the township. You can give it to a clerk. Whoever gets it, by law, shall immediately, and that means in our office, you run it down the hall, you email it, because that clock is running. Okay? Does that answer it?
Yes, thank you.
And one of the important things about that is that the FOIA coordinator is trained to know that for a variety of requests, who's most likely to have that information. So if you just make it, you know, in my office, again, you have about 500 people that work there. If you make it to just anyone in the office, it's not as though they necessarily know for other divisions that they're not in who would have that information. And you know, I've been there for the process of even trying to figure out who's most likely to have that so that we can get the response the quickest. And that happens, I guess, the bigger of a government body that you get, the more issues you're going to have trying to figure out who would have that information. And so sometimes that is how some of the time is spent. So while you think that people are trying to, you know, potentially avoid answering your questions, really sometimes it's trying to figure out who's got this information. Because depending on the nature of the request, that can sometimes be an issue. Does anybody else have any timing related questions? Okay, well, I'll move on then to the third thing on the list here, which is exemptions. Section 13 of the FOIA statute addresses exemptions from disclosure, such as public body as a school district, intermediate school district, or public school academy, withholding of information required by law, or in possession of executive office. There are 4 general categories of exemptions. Records of a personal nature. So in, is it Mager v. Department of State Police? Did I pronounce that right? Okay, Mager. Where the courts use the customs, mores, or ordinary views of the community to determine what is private or confidential information or embarrassing or intimate details of a person's life, or what harm, threat, or endangerment might result from public discourse. Now, these are records that would impair, secondly, records that would impair the safety or security of a public institution, or the safe and efficient operation of police or military authority. Records exempted based on public policy, records exempt by other statutes, state or federal, such as HIPAA, which is, of course, a person's medical information is protected by HIPAA, and that actually supersedes the FOIA statute. Tom, before we move on, I wonder if you might be able to give us an example. If you say a record's exempted based on public policy, what kind of public policy do you think that would? Do you want to use the microphone so everybody can hear Tom? I think it's important that people better understand this, because what's public policy, right? That could mean anything.
Right. Well, public policy is a general term that indicates that the legislature, on behalf of the people, say this is something we want for the welfare of the people. So, for example, under that general category, you will find exemptions for records that would disclose the physician or doctor-patient privilege. How could a public body have such records? Well, you look to our Department of Corrections that runs hospitals, there are a lot of records that are public records of the state of Michigan dealing with the doctor-patient records. So the doctor-patient privilege, the attorney-client privilege that Attorney General Nessel referred to as on our behalf as attorneys for the state of Michigan. There's a deliberative process privilege. For example, 4 engineers of the Michigan Department of Transportation are debating on blueprints for a new bridge. This is purely hypothetical. We're all safe to go home. And the one engineer among the 4 says, I don't like these blueprints. I think if we build the bridge according to these blueprints, the bridge is going to fall. And the other 3 say, oh, come on, you're a chicken little, the sky is falling, and we're under a time constraint here. Come on, come aboard just for fraternity's sake at least. Let's go ahead. And he says, no, I'm writing a memo to the director, giving him my honest beliefs on that. Now that memo to that director, it's in writing, is a public record subject to FOIA and could be, it's presumed, disclosable, right? But if that one employee says, I don't think I want to put it in writing because I might embarrass myself, and you're all sitting out there saying, put it in writing, put it in writing. We want that director to know that. That memorandum could be withheld from public disclosure under the FOIA per public policy. It's called deliberative process privilege, frank communications. We want our state employees, all public employees, to what? Speak their mind, to be candid, to be frank. You're out there saying, my right to know, which is the underlying right of FOIA, it can take a backseat temporarily to my right to be safe as I traverse bridges in the state of Michigan. See, it's a balancing, isn't it? So I didn't say that memo isn't subject to subpoena or other access, let's say through a discovery in some lawsuit against the state of Michigan. No, we're just talking FOIA. That's public policy. So those are examples of it. Okay.
Well, while I have you here, let me ask you this. So in terms of records that would impair the safety or the security of a public institution, for instance, could you give us an example of that?
So, for example, the Michigan Department of Corrections or your county jail gets a FOIA request for the blueprints of the jail. And your FOIA partner is going to say, do you want that in color or black and white? And by the way, Eagle Harbor Store has a sale in shovels if you're interested. We're not likely to give the blueprints of the jail out under FOIA. Why? Because FOIA is, there's a 2-party relationship. It's the public body and who? The requester? The world at large. Once it's in the hands of any person out there, the intended use, the motivation, purpose, identity, all that's irrelevant. Once it's out, it's out. It could be on the internet in 10 seconds. So again, it's a balancing test where the Department of Corrections in this case would have to tell in great specificity the requester why you're not going to get the blueprints under the FOIA. That's an example.
Thank you, Tom. Guys, everything is a reference to Shawshank Redemption now somehow, you know. But those are good examples of these exceptions. Now, one of the most common questions on exemptions that we receive are based on personal information. Now, the exemptions for records of a personal nature is an important one, right? Because in some instances, information requested may contain very personal information about a person. However, that doesn't mean that we should jeopardize their safety and their well-being or compromise their rights or disclose personal information like social security numbers. And in that case, you can redact, but we recommend that you redact with a scalpel and not a sledgehammer. And there's a two-pronged test that you can use for this to determine, as we do, whether or not the information you're seeking is exempt. Now, prong one, the information must be of a personal nature. So again, we'll cite that same case, Manger, thank you, did I get that right? Okay. Versus Department of State Police, where the courts use the customs, mores, or ordinary views of the community to determine what exactly is private or confidential information, or embarrassing or intimate details of a person's life, or what harm, threat, or endangerment might result from public disclosure. And that was a landmark case in which the courts used our office's amicus brief as a decision-making guide. Now, prong two, disclosure would constitute a clearly unwarranted invasion of an individual's privacy. So in ESPN v. MSU, which is a pretty recent case, it was determined if the material sheds light on whether the public body is functioning properly and consistently with its statutory and constitutional mandates, it is not a clearly unwarranted invasion of an individual's privacy and thus is not exempt from disclosure. And fun or not so fun story for me, but during the course of the campaign, there were some Republican operatives that wanted to obtain my personnel file from Wayne County from the many years I served as a assistant prosecutor at the Wayne County Prosecutor's Office. And I received a not so exciting phone call from the county executive of Wayne County's Warren Evans to tell me that they sent over my personnel file, but they had sent it over so quickly that they had forgotten to redact anything from it. So it had my social security number, my driver's license. There were actually medical records because I had taken a leave of absence when my children were born, and had my medical information in there, and so on and so forth. And I was like, that's not cool, man. That is not cool. But I mean that you can understand how scary that is. So in terms of, turnaround for FOIA requests, I think we all want to get our information in a timely manner, but I think we all understand the great importance in having FOIA coordinators take their time to ensure that they properly redact our personal information. And nowadays, obviously, in no time at all, you have your personal information go to an unfriendly entity or anybody who might want to do you harm. And, there are obviously a myriad of crimes that can be committed against you by virtue of having that personal information. And unfortunately, we see that in our office on a daily basis because identity theft, one of the fastest growing crimes that we have in the state and in the nation. So clearly, you can understand there's an importance from that perspective. But that being the case, let's take another question or two if anybody has any in terms of those exemptions. Yeah?
Who is the gatekeeper or authority or interpreter of those exemptions?
Well, it's initially the FOIA coordinator at the office that you're seeking it from. They make those initial decisions, and of course, when they send you back, whether it's a denial in part or in full, they have to specifically list whatever the exemption is that they're utilizing to deny your request. But of course, that can always be appealed.
Follow up, what's the process in which additional exemptions are added to that section 13 and or which the existing ones are modified or removed as exemptions?
You mean legislatively? Is that what you mean?
Is that what it takes as legislation?
Yeah, the legislature would have to amend the FOIA statute if they wanted to either add or to remove any of those exemptions. I mean, there's always case law out there in regard to the courts having to interpret what's meant by those exemptions and how far-reaching they are. And those, cases, the precedent set in those cases could change from time to time depending on the court that evaluates it. But if you wanted to wholesale change the statute, that would require the legislature to intervene. Oh, we got a lot of questions here. Yes, ma'am.
Was FOIA instrumental in getting information about the people involved with the Flint water situation and Larry Nessel?
Well, I mean, obviously they were journalists that wrote those stories, both of them. And I would say that, I know that they had done, for instance, with with MSU, a lot of it came from individuals who spoke to the reporters. They interviewed a lot of the young women that were involved. I know that they also did FOIA requests, of course, but I think most of that information probably came from just talking to individuals that were willing to come forward. On Flint, I think it was a number of things. Tom, you were at the office during that time period. Do you want to speak to that?
Yeah, I would think so. Well, anytime you have a situation like with Flint water, you're going to have resources coming from many different quarters. Now, FOIAs may come as a result of that. In other words, as the press on our behalf is looking for more information about an allegation being raised, then they know where to direct it. So where do you start directing? Does it go to the city of Flint? Does it go to the Department of Environmental Quality? At some point, no pun intended, the FOIAs are flooding in because of the amount of more information that's being stockpiled one on top of each other. But FOIA is always kind of in there, reaching out to pull more information in. So I haven't really sat back myself. I think everybody in our office has to see what is the history of this. It's going to be some reporter who's going to write a book on it, I'm sure, that will say, I studied all of this information, and there will be something about how FOIA requests. But how many of us see, reading the newspapers, pursuant under a FOIA request, ... something happens. We see that term out there all the time. So I would say in the vast majority of public events such as the Nessel, the Catholic Church, the Flint water, or these massive investigations going on, FOIA is going to play a role, inevitably.
Yeah, it's interesting though because you've heard me talk about the MSU investigation. Here, our office was invited in by the Board of Trustees to do a full investigation, or what we thought was to be a full investigation into really what had transpired with Dr. Nasser. And even though that we have taken those cases into court, still we have 6,000 documents that we're not able to look at because the university has cited attorney-client privilege. And that's after a law enforcement agency was invited to do an investigation. So you can imagine the number of documents that would be withheld just through a FOIA request, if that's the kind of problem we had as attorneys investigating. So while FOIA is great, obviously, it certainly doesn't mean that you're going to get all the information that you're looking for. And when you look at the Flint water crisis, and I say this not through the lens of being in the office of Attorney General, but just being a citizen and observing it, understanding all the documents that you would want to get involving the governor, that you can't. You simply can't because, of course, that office is exempted from FOIA. And, I'm sure there's a lot of information that the public would have really wanted to receive it as quickly as they could as that situation was unfolding. But were not able to, and the press were not able to do it through that mechanism either. So that being the case, let's move on, and I'd like to switch. Oh, more questions? Okay. Sir, you wanna?
There have been a number of instances where government agencies have charged really outrageous fees for disclosure of the information. Is there any remedy for that other than an appeal to the body and maybe the courts?
There is. Do you want to talk a little bit more comprehensively about? And it's pretty clear in the statute. I'll just say, but
Well, the legislature amended the statute about 3 years ago to impose on public bodies even greater accountability. So a public body now has to provide a requester with a detailed fee itemization form. It's your hardware store nuts and bolts invoice. And we always did that at our office. We've been doing that for years. And it says in the statute, you can only charge your actual costs, no more, no less. And if something is characterized as an outrageous or over-the-top bill, something's not right there. Your gut tells you that. So it's a matter of pushing back. The legislature also amended FOIA to allow you now to appeal the fee, which you alluded to. And that fee appeal goes to the head of the public body. From there, it can go to the circuit court in terms of local public bodies, court of claims for the state of Michigan. Court judges, and I've been in those courtrooms watching some of these cases. We have very few that we have to defend because the state doesn't get sued very often under FOIA. But as to those other cases, judges don't take it lightly if they believe that the public's right to know is being thwarted by fees that do not meet the test actual costs. And so, of course, you've got to be using the fee form. And if the fee form's not being used, then that's something that I certainly would complain to. I'd complain to my legislators. I would complain to everybody that there's non-compliance here, short of having to sue. And because you are entitled to attorney fees if you prevail in the FOIA, the legislature does intend for all of us to be private prosecutors. Because if you prevail, you shall be awarded your attorney fees and costs. So an attorney might say, your case looks good, I'll take it and wait for the fees at the end so that you can get that in court. There's no criminal provision, so a prosecutor or the attorney general can't intervene. But we do advise and recommend to citizens who contact us, here are the procedures.
Okay.
Watch out before Tom walks too far away. Yes, ma'am.
Can a public body circumvent the FOIA by agreeing not to disclose information that would normally be available in a lawsuit, settling a lawsuit?
There are two cases, and I can't remember the names per se. They'll come to me eventually.
Just go with that major case.
I go with it. But yeah, exactly. There is a case that's best put. A public body cannot contract its way out of its FOIA obligations. So the answer is no. That would be void. That contract would be void ab initio is the Latin phrase. It's void from the start because you cannot contract your way out of state law, generally speaking. Okay. Yes.
Two questions here, really. If you can convince the prosecutor that there is a likely chance that something illegal has happened, can you ask him, as if he's working in state court, to get all the relevant information, you think, from the agency for free on a subpoena because he is part of the state, he is part of the government, and they are part of the government, and it's a government function to prosecute criminals?
Well, before I turn it over to one of the best prosecutors in the state of Michigan, a subpoena is another way of accessing public records, not to be confused with FOIA. It's a different
but I mean, if FOIA was a big problem, or you didn't think it was your responsibility, if you can start a case, can you use the prosecutor's office to get it, because it would be a lot easier for you?
Right. Well, if it's a criminal case, of course, the prosecutor has an obligation to have. Generally speaking, you have to have a reason, and usually there has to be a case that's open in order, right? So there has to be an ongoing case that you can caption for the purposes of the subpoena. There's other investigatory tools. There are ways to get investigative subpoenas and other things of that nature. But are you saying that you want information, but you can't get it and just ask your local prosecutor, your county prosecutor to get it for you? Because I don't think they're likely to be very
Well, I'm just saying, if
open
you
to
think that there's something you're not happy with and you think you have enough information that you can show that there was a likely wrongdoing, instead of getting all the information and then taking it to him, just show him other information that shows that it's likely and let him go
Well,
do all the
firstly, normally you would go really not to your prosecutor's office, but to a police agency. Now that might be the Michigan State Police, it might be county sheriff, it might be a municipal law enforcement agency, and normally that's where you would go to report something in the event that you suspected sort of criminal wrongdoing, because most of the time the prosecutor's office will have to go to that, someone has to present that case to the prosecutor, and they can work in concert together, and they often do. But, I think it would be like any other situation where you suspect or you have reason to believe that there's some sort of criminal activity, and then of course you would go to law enforcement, but then one of those exemptions would kick in, because if there's an ongoing investigation involved, that is a reason sometimes to deny a FOIA. It depends on what it is, but if you're looking for information from a law enforcement agency or from a prosecutor's office, and you have a criminal case ongoing, they can use that, of course, as an exemption.
The other thing I was going to say, have you reviewed, since you're coming to office, or plan to review, the technical merits of our records such that you can make sure we're doing the best we can to be able to output all of our databases in some form like PDF or something like that, so as we could make things more efficient and cut the price, because it would be, obviously, instead of printing something, if you can just have your people accumulate the records and change, write them into PDF form, and then put them into a master file, and then send the master file to somebody, there'll be a lot less postage and a lot less printing.
Well, if I could just, not to interrupt, but
yeah.
Whenever possible, we do email the information. So more times than not is actually emailed rather than corresponded some other, through the mail. I don't know if there are any particular instances that you can think of where you would only do something through the mail as opposed to email, but mostly it's email.
Yeah, I can't say. Along the lines of best practices, the Michigan Department of Technology Management and Budget oversees all record and retention disposal schedules for the state of Michigan, state, county, and local. They are constantly in touch with all local units of government, all their records management people. They have seminars, they put out white papers on the best practices. So I know a lot of that's going on. I'm not sure if that's getting to what you're saying, but
yeah.
the DTMB is the overarching tech people here in the state, and they work diligently with all local units of government on these best practices. And there's many professional associations. One is, the acronym is ARMA, and it's Association of Records Management Administrators. Anybody from ARMA here? I see a few heads nodding. So a lot of that's going on kind of behind the scenes, and it's encouraging to see that.
If you want, we're going to go ahead and move on to OMA now, and we'll take some more questions after that. Again, OMA, Open Meetings Act, this is quite literally about opening the doors to an open government. And I said it earlier, but it's worth repeating. A government accountable to the people is at the core of the United States Constitution. And again, in Michigan, all political power is inherent in the people. So, like FOIA, OMA promotes governmental accountability, and it fosters openness in the government to enhance responsible decision making. It requires certain meetings of certain public bodies to be open to the public. And these meetings are required to give public notice, and a meeting cannot be held unless the public notice is given consistent with the act. So for our office, one of the top questions we receive in this regard has to do with closed sessions and special meetings. Well, closed sessions are permissible to have a discussion, but only for one of a few permitted purposes, like dismissal or disciplining of personnel or students, trial or settlement strategy, application for employment to a public office if the candidate requests that the application remain confidential. However, their interview shall be held in an open meeting, and some others. This is all outlined in Section 7 of the Open Meetings Act statute, which says, 1, that a 2/3 roll call vote of members elected or appointed and serving is required to call a closed session, except for the closed sessions permitted under certain sections, 8A, B, C, G, I, and J. The roll call vote and the purpose or purposes for calling the closed session shall be entered into the minutes of the meeting at which the vote is taken. Number 2, a separate set of minutes shall be taken by the clerk or the designated secretary of the public body at the closed session. And these minutes shall be retained by the clerk of the public body, are not available to the public, and shall only be disclosed if required by a civil action filed under Section 10, 11, or 13. And these minutes may be destroyed 1 year and a day after approval of the minutes of the regular meeting at which the closed session was approved. So I strongly caution you about trying to skirt the Open Meetings Act by having one or more people just sit in the hallway outside the door of a meeting, which, believe it or not, has actually happened. So, you know, the way I feel about it is that if you're a member of one of these bodies, you signed up for this, you know, and you have to be prepared to have difficult discussions and have them in full view of the public. And these discussions and debates should not be held behind closed doors and away from the public eye. And of course, there are penalties for OMA violations. A public official who intentionally violates the act may be found guilty of a misdemeanor and may be personally liable for actual and exemplary damages of not more than $500 for a single meeting. So both FOIA and OMA together help shape a government that stays accountable to the people. And each of us has a responsibility, and I would argue an obligation, to ensure our public is well informed about all the happenings within our offices and of our government. So sunshine is obviously important for the work that we do, and it keeps our government accountable to the people and provides for a well-informed society that can contribute to the democratic process. But, you know, I'm not going to stop there, and I will open it up for additional questions because I know it has been a while since an Attorney General has held one of these seminars, and I want to ensure we answer as many of your FOIA and OMA-related questions as we possibly can. So we'll take additional questions, and I'll answer as many as I can, and by me, I mean Tom. So, and I mean, honestly, I am still learning this process. In my practice, I did sometimes use FOIA, and, you know, I got to know it a little bit, but obviously, you know, 31 years of doing nothing but FOIA all day, every day, has made Tom quite the expert, so I will cede to his expertise, but we want to answer as many of your questions as we possibly can. So, yes, sir?
So, in a FOIA request, if the response comes back so redacted that basically there's 15 prepositions that aren't blacked out.
So basically any case I've ever had with the federal government. Gotcha. All right. I'm familiar.
It seems that our options are limited from an appeal standpoint because typically whoever oversees the department is the one that reviews the material to see if it complies with whatever they feel it complied with. And it seems almost kind of a joke that you would try to appeal it because it seems you're going to end up in the same place. So it almost leads to us to think, well, we have to litigate it in circuit court to get the information.
Well, right, and that is the avenue sometimes, of course, that you have to go down. Fortunately, there are penalties that now can be assessed, and prior to the amendments, I mean, it was very hard to get that information. Also, it was very hard prior to recent times in that amendment to get attorneys to handle it because it was so hard to get attorney's fees. Would you say that's correct, Todd?
True, and also, that trial court judge is gonna see a clean copy, and he or she is not gonna be happy if they start to see that there is over-redaction, non-substantiated redaction. So no, I would encourage to go to court.
Right. Did you hear Tom's answer?
I did, and a follow-on to that. So under OMA, let's say hypothetically that we were encouraging the community to join in a conversation that is sensitive in nature, be it affordable housing, crime, gangs, whatever. And there was evidence that public departments, say hypothetically, maybe the Department of Public Safety.
I feel like this is now really hypothetical.
Somewhat subverted our efforts to create a forum where we could have an open public discussion and tackle that subject. And then they plan to have their own sort of meeting on the topic that was couched under an umbrella of private, confidential conversation. Are they required to fulfill OMA? Is the Public Safety Department required to fulfill OMA?
Well, yeah.
Let's talk about it.
You have to look at the definition of Open Meetings Act, what is covered. For example, the Attorney General's office is not subject to the Open Meetings Act because its decisions are not made by a board, a committee, a commission, a subcommittee, whatever. It's by an individual. Same with the governor's office. But a public safety department, in and of itself, is likely not, and this, again, I'm just giving you generality, is likely subject to the Open Meetings Act. Now, if there's a public safety commission within the public safety department that makes its decisions by a board, okay? The superintendent of the public school is not subject to OMA, but the school board is. The Department of Natural Resources is not subject to the OMA, but the Natural Resources Commission within the DNR is. You see what I'm saying? So in other words, if the decision making is by a board or committee, and it's going to be more than one person, then they would be. What you talked about first was a public gathering of people who wanted to, appears to me, to exercise their First Amendment rights of freedom of speech and assembly, whatever. That's one thing. And then if the public safety department of a given community is going to have a like situated public forum, they can do that. It's not likely subject to OMA. But again, I just repeated your question is all.
But I guess if they, and I perhaps might be stretching it a moment here, but if this so-called public safety department was involved in this sensitive conversation and they had to go to the city commission for funding to tackle that, would then their meeting and their notes and their records be covered under OMA and be subject to FOIA and not be protected by a private entity that doesn't meet this definition?
Well, anything that a public body generates, creates, that's tangible, even electronic records, is subject to FOIA. And if this this commission made a decision based on those tangible items, then that's subject to OMA. So, I mean, there's some, they bisect there at some point. But you gotta keep FOIA and OMA separate. OMA is about being a witness to decision making. FOIA is all that paperwork that comes out of that decision having been made. All right, so it's almost like a continuum, but they are separate. Again, I don't know that I've answered your question.
Makes me want to know what's going on out here in Grand Haven, though, because it sounds like you have some interesting things. Yeah.
So this here on taping and broadcasting for like school board specific, we're in a closed session and a parent of an individual, wants to record the board as we're talking about whether to expel or suspend a student. Is that individual allowed to record in a closed session? And then also another question on if you have heard anything about Kent County last year where the chair of the Board of Commissioners had the Sheriff's Department not allow anyone into a meeting unless they were pre-checked and a member of the press. Have you heard any update on that?
I haven't, but do you want?
Yeah,
Please, Rob.
yes, so, the last I heard on that, Michigan Press Association gave some pushback on the exclusion. Basically what happened, they had demonstrators on a regular basis at the meetings, and so then, the public body wouldn't let anyone in. They could watch on closed circuit TV. And, we said we don't think that that complies with OMA because you can't punish everyone. OMA allows a public body to expel from a meeting someone who is disturbing the peace. So the last I heard on it, they were allowing people in, and I think within the last couple of weeks they had another demonstration problem, so they shut down that meeting. But they did rescind that decision to keep everyone out of the meeting, the last I heard.
Tom, what about the closed session and taping of the closed session? No?
No, because it's no longer a closed session.
Right. Well, yeah, and it's really not a closed session if you're allowed to tape it. I can understand that. You know, we used to have these issues come up quite a bit. It's certainly not the same as OMA, but we had these situations come up in court quite a lot because there were judges who frequently thought they could just close the courtroom to the public for various reasons, and you really can't do that. And even though sometimes, you know, you could understand the arguments being made by counsel, especially if you had someone that was a victim or an alleged victim of criminal sexual conduct, or had some, you know, a child that was testifying, and yeah, they're much more nervous to testify in front of a full packed courtroom than they would be if there was no one there. But you just can't do it because the public's right to know supersedes the ability to close, to make what should be a public meeting private, or, you know, courtroom proceedings, which should be open to everybody, closed. And so, you know, you have to, there are areas that you have to balance, but obviously, you know, our hope is that you generally come down on the side of full and complete transparency whenever possible. That's the way I view these laws, and that's the way, personally, I'd like to see them interpreted.
I had a question about the ongoing FOIA request that I believe you can make. And that is, let's say there's a policy issue that is, you know, in process. And so you've made a FOIA request, you've gotten the materials at that point. But it's my understanding that you can have an ongoing FOIA request so that as more materials are generated, they are disseminated to you. Is that correct?
Yeah, I can address that. Yeah, it's a strange word in FOIA. It's called subscription. Okay. Like you're subscribing to Time Magazine or something. But subscription has been defined by actually our former Chief Deputy Stanley Steinborn, and that goes back historically, many, many years back to Frank Kelly's days. But the Attorney General saw that as meaning a public body that creates a document on a routine, predictable basis. So, for example, hypothetical, the Department of Natural Resources every month is going to publish a map about the conditions of streams and rivers in Michigan. The statistics may change, but that report's going to come out every month. You could subscribe to that for 6 months and renew it for another 6 months, then make a new FOIA request. But if someone were to say, I want all of the emails from the mayor to the director of this department, well, that's not predictable. Emails are not determined by even the writer. It might be a reaction to another email. Those would not fall within what would be considered a subscription. Not to say the public body couldn't agree to give you every email that's generated for 6 months. But that's the difference, at least by interpretation. Okay.
Thank you.
Yeah, and that sounds, I mean, it's kind of similar to, you know, mutual discovery orders that we have in court, where if you have the judge decided a discovery order for certain types of items, it doesn't mean just whatever items you have at that minute. It means if you continue to receive those types of items, you are obligated to turn them over to opposing counsel. And I think it's somewhat similar, but on a more limited basis, though.
Legislators are lawyers for the most part. So,
I don't know. I think there's only one in the state senate. There's only one attorney now. If I'm not wrong about that. I think it's Senator Lucida.
Yeah, but the laws will follow a lot of what goes on in courts.
Right.
By example.
Yeah, I mean it's similarly structured. So, yes, ma'am.
Dana, will you take a question in regards to an attorney general?
I will try, absolutely, yeah, go ahead.
In the recent election, 2 ballot proposals that passed were done in the lame duck session, rescinded by the legislature. And I understand there was a previous ruling by Attorney General Frank Kelly, and then that was obviously rescinded under the current Attorney General.
Not the current Attorney General.
No,
My predecessor.
under the current 2018 Attorney General.
Right. And you're talking about one fair wage, was one of the,
Yes.
one of the bills you're talking about. These are of course proposals that, were not on the ballot, in November because they were addressed by the legislature, who of course has an opportunity to decide whether they want to pass it themselves, and then to see if whether or not later on they, in the case of this past legislative session, to then make alterations to those ballot proposals, which had received the requisite amount of signatures that they would have been on the ballot if not passed by the legislature, correct?
Correct. In addition to the gerrymandering, and I don't recall the number of the proposals, Susan, do you remember?
2 was the gerrymandering
Yes,
proposal,
right,
yeah.
Right. But the power of the Attorney General changed the dynamics of what the people had expressed and voted for.
Well, when you see the Attorney General, it was the legislature that did that. Then of course there was a request to the Attorney General, and you're right, there was a different opinion than had been issued previously on a similar topic under Frank Kelly, and I will tell you that is a pending request that is into my office right now, that we're looking at as to whether or not perhaps my office would have a difference of opinion from my predecessor's office on that. And so I can't give you an exact time that we'll be issuing that, but obviously that's a very important question. I think most of us would agree with that. And in general, I would say there were probably a lot of people who were really upset in this state because so many people had worked very hard to get those questions on the ballot, and some incredibly significant issues that affect, I think, each and every one of us. And so the question will be, can a legislature in the same legislative session as those ballot proposals were voted on by the legislature and passed by the legislature, can they then significantly change what was in those ballot proposals? And I guess the answer to that is stay tuned.
So the participation is wonderful, really appreciate that. Unfortunately, we do have a time constraint, so I think we have time for one more question, if you can do one more.
Sure.
I'm gonna let you pick it.
Okay, well, that's a lot of pressure. All right, yes, sir.
Tell us what you really think about lame duck sessions.
Yeah, I mean, I'm just so horrified by what happened in the last lame duck, and it really, to me, everything about the way the legislature should operate was really turned on its head, and of course it's made so much worse now because of our draconian term limits, because you have such a significant number of people in the legislature that will always no longer be there the next legislative session. So I think back in the olden days, before we had these term limits in place, probably the bulk of the people that are in that session are still going to be there the next time. Even though there's been an election, you're still going to have a lot of the same people, and they're accountable to the voters. But when you have such a significant number of people who are no longer accountable to the voters, and who maybe are looking for their next gig, which might be as a lobbyist, representing some entity that has actually an interest in some of that legislation, and of course we don't have anything on the books that would prevent you from going right from your current position to working for one of those firms, it creates a lot of injustice, in my opinion. And worse, the legislature, certainly not very circumspect when it comes to these massive pieces of legislation, many of them that are so quickly amended at the last minute and are so voluminous, there's no way there's no way that you could have people actually reading all of them. And I talked to a number of legislators who, you know, by the time the vote comes up, they haven't even had an opportunity to look at whatever it is that they're voting on. And that's, to me, that's not the way the government ought to operate. That's the exact opposite of how we would want our government to operate. And, you know, to see virtually no intelligent debate of any kind on some of the most important bills ever to come before the legislature. I mean, who wanted that? How is that a democracy? You know? And who wants that for our government? So I in particular, of course, was on pins and needles throughout the course of lame duck because much of it was aimed at limiting my powers as Attorney General. So just waiting to see what I was even, of all the things that I had run for, I really felt as though the Republicans honestly had made a list. And all of my campaign promises, one by one, I felt as though they were looking to make certain that I could not fulfill. And whether or not that had to do with action that I wanted to take in regard to PFAS, you know, boom, you know, there was legislation to make it more difficult to aggressively go after chemical manufacturers or industrial sources of PFAS or other pollutants. Whether it was my pledge to shut down Line 5, boom, you know, there was another piece of legislation establishing the Mackinac Corridor Authority and making it more difficult to shut down Line 5. I couldn't even believe it when we finally got to the bill that would have made it easier for puppy mills to operate because I had vowed to shut down puppy mills. I was like, oh my God, even puppies? I mean, come on, man. I mean, I literally looked through my list of campaign pledges, and it almost felt that way to me. And I will say, fortunately, Governor Snyder did veto some of the worst of these bills that would have impacted the way that I, as Attorney General, could do my job. Josh Cowell, who was elected in Wisconsin, was not so lucky. I thought that many of these laws seemed to be clearly unconstitutional and violated the separation of powers. And I think that it's not very, it's not thinking with a lens into the future. And what always is interesting to me is you want to say, and I look right now, for instance, as many of you know, I joined the lawsuit filed by California against the Trump administration in regard to the emergency declaration to build the wall and to fund the wall with money that had not been appropriated by Congress. And I just, you know, I wanted to say to those in Congress, and many of the, you know, many in Congress do not support it, whether they're Republicans or Democrats, but I want to say, you know, he's not going to be president forever, right? Yeah. I mean, you know, unless something goes terribly awry, he will not be there forever and ever. And one day you may have a Democrat in that position who's got a very different idea of what constitutes a national emergency. And I think about it very similarly when it comes to lame duck, you know. And I don't think any of us, irrespective of whether we're Democrats or Republicans or independents or other, you know, I can't imagine that any of us sitting here in this room or listening to this conversation really thinks that government ought to operate the way we saw it operate during this last lame duck session. So at this point, if we are going to keep these draconian term limits in place especially, I think we do need to eliminate lame duck altogether so that we can't ever see what happened last November and December happen again in the Michigan State Legislature. That's not good government. So, thank you. That was an excellent last question that allowed me to go on that very lengthy diatribe. So thank you for that. I really appreciate everybody being here today and for taking such an interest in this. And I promise throughout the course of my term in office, I will be able to answer personally more and more of your FOIA and OMA related questions and not rely so much on Tom. But it's been a great experience so far, and I look forward to doing everything that I possibly can in my capacity as Michigan Attorney General to create the most transparent state government possible. So thank you so much. everybody.